When the sex offender statute requires that a SORA hearing be conducted before release, does that mean release from jail or release from state custody generally? To find out, you have to read People versus Boone and Cotto, but it's 45 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of People versus Boone and People versus Cotto. The citation for this case is 2024 New York Slip Opinion 00928, published by the New York Court of Appeals on February 22nd of 2024. The issue in this case is whether a Sex Offender Registration Act hearing has to be conducted right before a defendant is released from the incarceratory part of his sentence with respect to a criminal case, or before release from custody generally by the state. To understand and appreciate the context of this case, the important background to know is that under Correction Law 168, which is the codification of the Sex Offender Registration Act, what we call SORA, the SORA statute requires a sentencing judge to make a determination before a defendant is released about whether a defendant is a sexually violent offender, a predicate sex offender. There's certain categories classifications that are given to a sex offender, as well as a sex offender risk level. A risk level 1, which is considered low, 2, which is moderate, and 3, which is high risk for reoffense. And in preparation for conducting a SORA hearing, the Board of Examiners of Sex Offenders conducts an examination and generates a report, a risk assessment instrument that goes to the judge and to the defense attorney and to the prosecutor that helps the judge conduct the hearing to help the judge determine what to do at the hearing. The other thing you have to know is that that's a criminal part. That's before a defendant is released from the criminal part of a sentence. The board does that sending of the report, and the SORA hearing is conducted. But a SOMTA is a civil commitment for sex offenders. There's another statute called SOMTA, which is a civil commitment procedure. It's under the mental hygiene law, and it allows the Attorney General of the state of New York to try to start a proceeding to place a sex offender with an organic brain abnormality or some kind of predilection to commit sex offenses that makes this person more dangerous to society generally. They can start a proceeding to have a defendant be placed in civil commitment in a facility, a treatment facility, because they're not safe on the community. They're not safe around others in society. And so that's the question. So that's the background that's helpful to understand. So what are the facts in this case? The facts for these two cases are very similar. In each of them, I'll talk about Boone first. Boone was twice previously convicted for sex offenses, including raping a 6-year-old child, and was adjudicated as a level 2 sex offender. He served his time on that case, was released, and within very short order, he was again prosecuted for pleading guilty and pled guilty to sexually abusing against another person. He abused and raped sexually 4 children that he babysat. For this, he was sentenced to 12 years in prison, followed by 20 years of post-release supervision. Ultimately, his conditional release date was September 10th of 2019. In preparation for his release from prison, the Board of Examiners of Sex Offenders prepared a risk assessment instrument, which they sent to the court because he was going to be soon released from jail. They suggested he be adjudicated a level 3 sex offender. But before he was released, the New York Attorney General filed an application to have the defendant civilly committed with the SOMTA statute. So in essence, there are 2 proceedings happening simultaneously. The SORA proceeding is scheduled, and the SOMTA proceeding is now being scheduled to have the defendant civilly committed. At the SORA hearing, the defendant says, it's premature. Don't conduct a SORA hearing right now because I'm not being released into the community. I'm going to be placed in civil commitment, probably. And as a result, it's not really a fair judge of what kind of risk I pose to the public because I might not go to the public for 20 years or 30 years or maybe 50 years. The judge denies the motion to dismiss or adjourn the hearing and finds the defendant to be a level 3 sex offender. Cotto is very similar. The defendant was previously convicted of raping a child. Less than 3 years after he serves his time on the first offense, he does it again and pleads guilty. And right before his SORA hearing, the same kind of thing, a SOMTA proceeding is filed. So in each of these cases, the judge denies the application to dismiss or adjourn and conducts the SORA hearing, finding the defendant a level 3. It appeals to the appellate division in each of these cases, and they affirm what the judges did. It goes to the Court of Appeals, and the question here before them is, what does release mean? What does the word release mean in the statute? Because it has to happen, the SORA hearing has to happen before parole, discharge, or release. But release from what? It's not clear. The defendants are arguing in each of these cases that release means release from state custody, and the prosecutors are arguing in each of these cases it means release from the incarceratory component of a criminal sentence. There's a majority dissent here. The majority says, we reject the contention the defendant is making and conclude, this is their quote, that sex offenders are released for purposes of SORA at the time they are no longer confined by DOCS, which is the Department of Correction, following the completion of their prison sentence, regardless of the possibility that they may be confined under SOMTA. So they think that release means only the incarceratory part of a jail sentence, because nowhere does it say release from release into the community. They say it's a singular process that SORA envisions, which is triggered by the 120-day period before being released from jail. So the defendants, they also say the defendant's plan would be unworkable because you'd have to follow the defendant and follow up with him 20 years, 30 years later, and then do a SORA hearing. It's too complicated. They say it just applies for release from jail. And they remarked that the two important goals of SORA is to protect the community by notifying them of the presence of individuals who may pose a danger and enhancing law enforcement's ability to investigate and prosecute future sex offenses. And those are furthered by conducting the SORA hearing before release from jail, even if they're going to get civilly committed immediately thereafter. There is a strongly worded dissent by Judges Rivera and Wilson, and they think that release means from any state custody. They say it's ridiculous, or they say it's not appropriate to say to do a SORA when they're going from this hand to this hand of the state. It should be when they're released from the state itself. But once again, the majority here is that that release means release from prison, and that's the case of Boone versus Cotto. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.